and final day of Caraconference 2023, brought to you by Caracol, Greater Cincinnati's AIDS service organization devoted to positively changing lives in the fight against HIV/AIDS. My name is Suzanne Bachmeyer. I'm the Director of Prevention here at Caracol. And for today's session, we have two law professors from the University of Cincinnati, and they are here to talk about laws and policies that impact public health efforts. We are so pleased to welcome Jennifer Bard and Ryan Thoresen.
Hi, good afternoon. Thank you so much for inviting us. Thanks to Caracol and to the sponsors. Ryan and I have divided up this really important topic into two halves. So I'm going to talk for about 20 minutes about the powers that states have, so individual states like Ohio or Michigan or Oregon, and how they are exercising them in ways that could affect access to PrEP. And then Ryan is going to talk for 20 minutes specifically about the religious freedom and gender discrimination issues that may or may not stop these efforts to interfere with access. And we're also going to, on a hopeful note, talk about possibly some solutions to increase access. And then we're going to open the floor to questions, so you have plenty of time to ask either of us. So, if we can get started, I think the next slide is just a big disclaimer. First of all, I don't know an area of the law that's changing faster than this one. So, for sure, we're going to give you the best we can as of the moment. But I also think it's important to say that we are talking as law professors. We're not giving legal advice, and we're not licensed to advise, but we can talk about the issues. And the other thing is the links, to the best of our ability, are Creative Commons access. So if there's an issue with them, we will deal with that. But I think that they're okay for you to see. They're mostly government illustrations. Okay, so we can get started. These are our credentials, and we both have backgrounds in this. As you can see, I've been doing this a long time. I was involved in AIDS policy since 1993, which was a very different and very hopeful time, which is when just even the first treatment drugs were becoming widely available. So from my perspective, the idea that anything like PrEP exists has always been just, would have been a dream. Which is why it's so important to maintain access. So first slide. Let me just tell you where we're going to end up. So I want to talk to you just so that you have this in your back pocket as events evolve over the next couple of months, certainly into this Supreme Court term, that the US Constitution creates a balance of power between individual states and the federal government, and a lot of things, but really specific to this, related to health and safety. So the federal government has unique powers and the states have unique powers. What's going on right now is, and the part that I'm going to be talking the most about, is that our current Supreme Court has I'll use the word hostility, suspicion to federal exercise of the powers that they have to promote health and safety. And this suspicion or hostility has led to supporting the nationwide challenges to federal authority that we're seeing across a wide range of topics, but certainly in regard to healthcare. And then the last thing that I'm going to talk about, which is more practical, which is I'm going to talk about specifically how protecting access to HIV preventive care would be a broader effort to add more legal protections to individual rights related to healthcare on the state and federal level. So that's where I'm ending up. So let's get started with where we are. So if we started right at the beginning, so with the really the second Constitution, which is the Constitution we're working under now, the states were very suspicious of a federal government. They tried to resist having one. Things didn't go well. States were printing their own money and having post offices and signing treaties. So they agreed to our current Constitution, But what they agreed to is they would only give up specific powers, and anything they didn't give up specifically, they would keep. So if we go to the next slide, where that is documented is in the 10th Amendment. So if there was any ambiguity that they weren't giving anything up that wasn't specifically listed, the 10th Amendment clarifies that. And the implication, although the words health and safety are nowhere in the Constitution, what that means, and it's always meant, is that individual states retain their ability to oversee health and safety matters in their own jurisdiction. So when you get to direct power over health and safety, that has always been a power individual states have, and it's one that they retain even after the Constitution. So if we go to the next slide, here's the 5 powers where I think this is really, evidenced the most. So one of the most important things states can do that the federal government has nothing to say about is license healthcare workers. They can set the standards, they can set the tests, they can set the fees, the reviews. They can do the same thing for hospitals, clinics, and pharmacies. After licenses, who can practice medicine, they can regulate how medicine is practiced. Informed consent, liability. The next thing is they can control malpractice liability. They can shield healthcare workers from liability. And the final thing that they can do, which they share with the federal government, but they also have considerable power over, is insurance issues. So that gives them a lot of tools to regulate health and safety. So how could they use this power to raise or lower access to PrEP? Well, one of the top things that they have done, just in regards to interfering with stopping the spread of HIV, is maintaining laws that criminalize even potential transmission of HIV. I know this is a group that's probably heard about this a lot, but 2 words, which is that in Ohio and a lot of other states, if someone is found to be HIV positive and has put someone else at risk of catching HIV, whether they have or not, that's a criminal offense. So all over the country, this, of course, disincentivizes testing. The other thing that states are doing is protecting physicians from liability for refusing to provide care. And that includes, prescribing medications that is against their conscience, very widely defined. We're seeing attempts now, so we're going to focus on prohibiting insurers in their state from covering certain services. One thing that hasn't happened, but that they could do, is impose restrictions on filling prescriptions for PrEP, narrow who can fill them, put in delays and burdens. And the other thing they could do, which no one has done yet, but which is certainly a concern, is the extent that they could ban HIV preventive care. No one's done that yet, but of course, we're all talking about this in the context of states that have banned abortion. So it really does fall in that category. So next slide. So that's sort of the worst case scenario. So what can the federal government do? Well, the federal government's powers stem from two parts of the Constitution. They can regulate commerce for the benefit of businesses, which is why the drug companies in a lot of ways are the biggest allies in this, in certainly with PrEP and with other medications, because what the federal government has the power to do is protect the market, the national market. So that's why the drug companies and the federal government are in alignment, and it's where the power to approve drugs comes from. They can control shipping, transportation, and advertising. The other thing that the federal government can always do is it can send people cash, just like sending everyone send everyone a check or a COVID testing kit. They can send money to states, like subsidizing Medicaid, funding Medicare, subsidizing pharmacies. And the sort of third category is just sort of on the other end. The federal government doesn't provide any direct health care to anybody but active duty military, veterans, and Indian Health Service. So there are no federal hospitals. The federal government's control over healthcare that happens in hospitals or doctor's office is through their funding of Medicare and Medicaid programs. So next slide. So that brings us up to Briarwood, and this is really the case where PrEP has come into direct discussion. So this is a case, Braidwood versus Becerra, striking down Obamacare's mandate that employers cover all preventive services. As people know, one of the big accomplishments of the Affordable Care Act, Obamacare, has a list of preventive services that people who offer insurance through Obamacare and employers who offer insurance to their employees have to provide without a copay. So the technical term is without cost sharing, but what that means is without a copay. And the way they identify those services is they have expert panels that review emerging, there were things that were in existence when the Obamacare Act was passed, and then as the drugs come onto the market, they evaluate them, and this expert panel says whether or not they are, they grade them A, B, C, and the Affordable Care Act says that you have to cover the A's and the B's. So has always, has been on the A's as long as it's been, in existence and development. And what the attack is, the direct attack, is on two very technical provisions of the Constitution that this Supreme Court is interpreting very differently than anyone else ever has. So that's the part I'm talking about. And then Ryan's going to talk about the other part, which is equally serious, which is these employers are saying if they have to pay for PrEP as part of the insurance, that would violate their religious beliefs. So I'm going to talk about the ways they're trying to block it in the first part. I have something on the next slide about that. All right. So it turns out to be a very dramatic attack because while they are attacking PrEP, they're also attacking all of the preventive services that the Affordable Care Act says has to be paid for. So everything, from flu shots to mammograms, they are calling into question the entire infrastructure of identifying preventive services. So even though PrEP is the focus of their objection, the possible consequences are to remove many preventive care services. They'd like, I think, all of them, but certainly many of them from the requirement to provide without copay. So the direct, harm to that would be, first of all, employers and insurers could drop them, or second, they could just make them very expensive. Now, on the left hand of this slide is an acronym that you will be hearing a lot about over the next couple of months. So who identifies this? Well, there's the committee, and it's called the Preventive Services Task Force, PSTF. And they're a group of experts, private volunteer experts, who review prescriptions, tests, they review preventive measures, and they make recommendations. So what the attack is a complaint that this group was appointed by the Department of Health and Human Services, but not directly by the president. Now, that is an interpretation of who has to be appointed by the president, that if you took that literally, would essentially mean not that the president personally had to appoint every single person in the federal government who could make a decision. Unfortunately, the definition, what they're talking about, the provision of the Constitution, is pretty vague, and it sets up two categories: major state officers that the president has to nominate for appointment, ambassadors, senators, agency heads, and they recognize the second category of minor that does not require presidential involvement on the one hand. On the other hand, they don't define it. So if the definition of minor starts to include everyone, it will directly mean that this group is illegally appointed. So if we go to the next slide, you can sort of get a better idea of what that means. So what's the worst that could happen? Well, significantly, because the Supreme Court has had no hesitation to revisit, both revisit past opinions and reverse themselves, or simply take up issues that no one has ever questioned before. No one has previously spent a lot of time thinking that every advisory committee in the whole federal government has to be selected by the president. If that argument prevails, then that would have an amazing crippling effect on the entire way that the Congress has set up the agency system and how they rely on volunteers. The other thing that is in question is a second relatively obscure doctrine called the non-delegation clause. And it limits Congress's ability to delegate its powers to unelected officials without clear guidelines on how to use it. Up until maybe 5 years ago, that would have meant Congress couldn't have given somebody else the power to declare war. But taken at its most literal meaning, there's been a lot of decisions, one after another, where the Supreme Court has simply questioned every agency decision, saying that they didn't have specific enough guidance from Congress to make that decision. So essentially, it is another way of interfering on a large scale with every single government agency decision. In the end, they're not saying that Congress can't have agencies or that they can't have experts giving opinions, but what they are saying is the way they've been doing it for the past close to 200 years is unconstitutional. So what they're essentially doing is being disruptive because the whole federal government is set up on the old view, which is that this was an appropriate way to run administrative issues. So next slide, I think that's sort of the, so could PrEP be taken off the market? I'm going to shift topics. I certainly think that what I've just talked about before are sort of mischief-making efforts to make PrEP more expensive by saying that it can't be included as a mandatory preventive service or as a low-cost service under Obamacare. I do just want to say a few words before we get to Ryan, in case you're sitting there thinking, okay, well, what does this have to do with the other pretty dramatic change that's going on, which is the attacks on FDA-approved drugs, such as abortion-inducing drugs and gender-affirming care. One of the things that PrEP has going for it is an FDA-approved drug for the purpose that it's being used. So it does not have the avenues for attack as the puberty blocking drugs and to some extent some of the newer abortion inducing drugs. Again, very inside baseball, maybe very technical, but it can't be attacked on the same grounds, and it isn't being, which is why they have found this sort of different pathway. Next slide. So it's not exactly the same. Also, Section 1557 of the Affordable Care Act, and this will lead also into what Ryan is going to talk about, prohibits discrimination in healthcare. But on the other hand, the Supreme Court gets to decide what discrimination is. And as we know, they have said that it has nothing to do with, it is not preventing the banning of abortion services. So we are sort of sitting back and we're just going to have to see how that plays out. And 2 more slides. So what rights are at risk? Certainly, everything that we would have thought we knew about how the federal government could allocate its resources to support HIV preventive services or care can be at risk if they can be reconsidered. So if we go to the next slide, what can be done? Well, one of the things that can be done is to pass more specific state laws protecting preventive care, amending state constitution, passing federal laws, amending the federal constitution. To be more specific, because what's been going on so far is sort of relying on general authority. And if there is no general authority, the next step is to say, okay, well, let's be very specific. In our state, this particular kind of drug is protected. Next slide. The other thing that, taking a step back is, of course, the funding for PrEP is provided under all 4 of these federal programs. And to the extent that they are funded by Congress, simply, conveying to Congress how important it is that they remain funded is another direct pathway to protect their accessibility. Next slide. Sure, I've got everything right. Okay, so here are, as I said, I told you I would end on a more positive note. Here are some things that states could do that the Supreme Court that would lower barriers to accessing PrEP. One thing they could do is require insurance to cover ACA recommended preventive services. And that would in some ways bypass the question about whether the way the federal government is identifying preventive services is correct. Another thing that California is doing is simply to widen the ability of providers to prescribe PrEP. So in California, there's a bill that allows pharmacists to prescribe. Another thing that is within the hands of state government is to allow prescription to minors without parental permission, provide funding, of course, that's always important. And again, because states have almost complete power over the practice of medicine, they also might be able to make HIV prevention drugs available over the counter. And so if we go to the next slide, I think we're pretty much done. The last thing that I would say, and then we can go to Ryan, and if you have more questions about this, I'm happy to talk about it more. Another pathway to protecting PrEP in particular, or any specific kind of medical intervention, is to take the next step beyond amending a state law, which is to amend the state constitution. So if a state passes a law, of course, the next legislature can always change their mind. And the advantage of a constitutional amendment is it bars future legislators from undoing what the amendment permits. So if there was an amendment that mandated that Medicaid included preventive services identified by this task force, could be specific to HIV. And then this is my segue to Ryan, which is it's also would be possible to prohibit gender-based discrimination and to define it in ways that would incorporate access to PrEP. So I think that's as much inside baseball as I could, inside the federal government, as you might want to hear in 20 minutes. But I would say that a lot of the things that we thought the federal government could do with the powers that it had are being called into question and eroded by a Supreme Court that takes a very different view of how Congress can exercise its powers. So Ryan, is that a good segue to you?
Yeah, that's great. And thank you for the that kind of background. I think the portion that I'll be talking about kind of goes into the question of individual rights and what can individual medical providers, but also individual patients assert as rights in seeking access to PrEP. So that context of the ongoing debates in the federal and the state arenas is really helpful. And just also wanted to thank the organizers for having us. It's really great to be able to kind of speak with all of you and share some questions after the presentation. So one of the things that Jennifer mentioned that has really been central to access to medication in the wake of the Affordable Care Act is the First Amendment and the protection of freedom of religion. So the First Amendment says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, which essentially limits not only Congress's ability, but government's abilities to restrict the free exercise of religion. This doesn't mean that people have free reign to just ignore any laws that they feel conflict with their conscience. In fact, there's a Supreme Court case in the early 1990s that interpreted the free exercise clause fairly narrowly to say that as a matter of US constitutional law, the government doesn't have to carve out religious exemptions to laws that are both neutral with regard to religion, so they're not targeting any one specific religion, and are generally applicable to the public. So in the next slide, this case is called Employment Division versus Smith. In this case, the Supreme Court was presented with a situation where someone was fired from their job for using peyote, ceremonial peyote in Oregon in violation of Oregon's drug laws. And when they sought unemployment benefits from the state said no, because they'd been fired for a drug-related offense. So the person sued, saying that peyote was part of their religious practice, and the Supreme Court ultimately had to decide whether the state was obligated by the First Amendment to the Constitution to grant them an exemption from the generally applicable criminal law. And the Supreme Court ultimately decided in an opinion written by Justice Scalia that, quote, if prohibiting the exercise of religion is merely the incidental effect of a generally applicable and otherwise valid provision, the First Amendment has not been offended. So what that means is that, in the healthcare realm and other domains, the state can pass laws that religious believers have to follow, so long as the law is not motivated by controlling particular religious exercise and is generally applicable to everyone. And interestingly, the Employment Division versus Smith case was seen at the time as a somewhat conservative outcome. The opinion was written by Justice Scalia, and in part it was seen as conservative because it prevented people who were part of smaller or more obscure faith traditions from obtaining exemptions from general laws. So on this slide, we see the Religious Freedom Restoration Act. In response to the ruling in Smith, there was this large bipartisan majority in Congress that responded to the new kind of narrow interpretation of the First Amendment by enacting the Religious Freedom Restoration Act, or RFRA. And RFRA creates a statutory right to free exercise, saying that even if the First Amendment to the Constitution doesn't require religious exemptions, in some instances, Congress will require religious exemptions. So here, this is a portion of RFRA that says that government may substantially burden a person's exercise of religion only if it demonstrates that application of the burden to the person, one, is in furtherance of a compelling governmental interest, and two, is the least restrictive means of furthering that compelling governmental interest. In more straightforward terms, this means that when a person claims that enforcement of a law would violate their religious exercise, Congress has put the burden on the government to show that it has a really compelling reason to enforce that law against the person, and not just generally, but against that specific person or group of people. So on the next slide, you can see this has proven consequential in a lot of the high-profile challenges around contraceptives or abortion-related medication. And probably the most famous case in this vein is Burwell versus Hobby Lobby stores, or the Hobby Lobby opinion. So if you'll recall, as Jennifer mentioned, the Affordable Care Act provides coverage for many kinds of preventive care, which was subsequently defined to include contraception. And in Hobby Lobby, businesses that didn't want to cover contraception for their employees sued, saying that it violated RFRA. Now, they couldn't really plausibly argue that it violated the First Amendment because under Smith, the Affordable Care Act is a neutral, generally applicable law. The government or the Constitution doesn't require that the government make special exceptions for religious believers. But under RFRA, they had a stronger challenge. So applying the standards in RFRA, the court said that providing employees health insurance that covered contraception did substantially burden these employers' exercise of religion. And that even if they assumed that covering contraception advanced a compelling governmental interest, there were less restrictive ways that the government could achieve that interest. So they very generously interpret the idea that the employers have a sincere religious belief against contraception, that finding them for failing to provide this insurance would substantially burden that religious exercise. And then they say, we'll assume that the federal government has a compelling interest in ensuring that their employees can access contraception. But they say there are other ways that the government can achieve that. It could provide contraception directly from the federal government. It could pay for it directly without needing the employers to do it. That there were other ways they could do it without disrupting access to contraception. So RFRA and this, you can imagine how the decision in Hobby Lobby might kind of mirror what employers might do in the context of PrEP. To say that they are not under an obligation to provide coverage for PrEP so long as there is another less intrusive way that the federal government could just provide it directly. Now, RFRA covers federal lawmaking like the Affordable Care Act, but a lot of states have their own mini RFRAs at the state level. And as far as I know, Ohio does not, but it does have state constitutional provisions that are protective of religion, that essentially impose the same kind of test as RFRA, saying that if someone alleges that their religious exercise has been burdened, the government has to show that it has a really compelling need to enforce compliance with the law, and that enforcing compliance with the law is the least restrictive way of achieving that need. So on the next slide, one other issue that comes up in this context is that in addition to the kind of general provisions of the First Amendment and RFRA, many states have enacted narrower religious exemptions in healthcare, as you can see on the map. So the states in dark orange, they allow medical professionals to refuse to provide services if they allege that doing so would violate their religious beliefs. You'll note that Ohio is one of those states. This was slipped into a budget bill in 2021, which says that medical practitioners or institutions or insurers can decline to perform healthcare services that violate their conscience. And that can be in the context of moral, ethical, or religious beliefs. It doesn't have to be, kind of consistent with an organized religion that they belong to. And importantly, they can participate in referring the patient to another provider who will give them that service, but they don't have to. If they feel that making that referral would also compromise their religious beliefs, the statute says that they do not have to do it. So Ohio's not alone. There's at least 9 states that have religious exemption laws that allow medical professionals to decline to provide services if it would conflict with their sincerely held beliefs. And this would be bad enough if it was overriding state non-discrimination laws, but many states don't have robust anti-discrimination laws that protect many of the groups of people that take advantage of access to PrEP. So there are only 15 states that prohibit insurance discrimination based on both sexual orientation and gender identity. The Affordable Care Act has a provision that prohibits discrimination based on sex, which they've interpreted to include sexual orientation and gender identity. But provisions at the state level are really severely lacking, where many states do not themselves, prohibit discrimination based on sexual orientation and gender identity in healthcare. And the lack of those explicit protections means that in many instances, patients and other people don't know how to contest discrimination that they've experienced. So on the next slide, this has real world impact. Prior to starting my position at the College of Law, I used to work for the LGBT rights program at Human Rights Watch, which is an international human rights organization. And one of my focuses was the United States. And so during the Trump administration, I interviewed LGBT people in Mississippi, Tennessee, and Michigan about healthcare discrimination that they had experienced. And Human Rights Watch released a report called "You Don't Want Second Best: Anti-LGBT Discrimination in U.S. Healthcare" that documents some of these stories. And the one that's on the slide that kind of leads the report is the story of a lesbian woman in Ferndale, Michigan, who, had made arrangements to get a pediatrician for the daughter that they were expecting. When their daughter was 6 days old, they brought her in for an initial appointment, and were informed that the pediatrician had learned that they were two women having a child together, and that she wouldn't be able to work with their 6-day-old child because she objected to their lesbian relationship. And the report was published in 2018, but the key themes are still relevant and are borne out by some recent data from the Center for American Progress and others. One of the themes that is covered in the report is the difficulty that many people encountered in accessing PrEP. And there were various reasons for that. One was just a lack of accessible services for people, whether this was specifically related to their sexual orientation or gender identity or not. So, many people were not able to afford healthcare services. Many people, because of geography, didn't have providers near them that were competent to provide PrEP and other services. Many people didn't have insurance coverage or insurance coverage that would allow them to afford medications. And then many people just didn't know where to find LGBT inclusive providers and get access to the services they needed. A second area of concern was discrimination and mistreatment by providers. So many providers discriminating against LGBT patients. A third related one was refusals of service, where people were turned away from providers who said that they don't work with trans patients or things to that effect. And then the last, which is really worrying, is just a reluctance to seek care. And one of the patterns that emerged from some of this qualitative research was that when people expected that they would face that kind of discrimination, or worried that, if they asked about PrEP, their doctor might think about them differently or might start discriminating against them, people just forewent care. They just didn't get care and didn't seek it out because they didn't know what to expect or expected that they would be discriminated against. So I'll pivot now to, the question of when people do have a right to healthcare. We've talked about the way that religious exemptions have been used and what harm that can have. But government entities, as Jennifer mentioned, retain a considerable amount of power over healthcare. And that's often good, right? It means that sham procedures can be limited and medications are tested and personnel are licensed. The US Constitution doesn't contain an individual right to health that would allow, you or I to assert a right to health in court under the US Constitution. There are 13 state constitutions that do reference health, but usually that's, some reference to the state being obligated to promote and protect public health rather than a kind of actionable right that we could insist upon in court. And so, in thinking about the scope of individual rights to health, I think it's really helpful not only to look at the decisions around PrEP, but also the decisions around abortion, contraception, and gender affirming care. So this slide shows that right now the debate over gender affirming care is being litigated in many courts around the US. There are 22 states that in the last 3 years alone have prohibited at least some forms of gender affirming care for transgender children. The bans vary in their specifics, but all of them prohibit doctors from providing certain forms of healthcare to their patients. So on the next slide, the federal courts that have considered challenges to these bans have generally been very skeptical of them, especially the district court level. A very ideologically diverse group of judges have enjoined enforcement of these bans on gender affirming care, and for various reasons. One that I won't get into is in some instances, they've said that these violate the First Amendment right of doctors to recommend care that they believe is warranted to their patients. It essentially gags doctors from making recommendations for gender affirming care. But the two that I want to focus on are the rights of patients and their families under the 14th Amendment. So in some of the cases, courts have found that bans on gender affirming care violate the right to equal protection of the laws. This is a section of the 14th Amendment to the Constitution called the Equal Protection Clause that courts have interpreted to prohibit gender discrimination. And courts will give a kind of intermediate level of scrutiny to gender discrimination, requiring that the government has to have an important government interest to discriminate on the basis of gender, and has to do so by means that are substantially related to that interest. So in the gender affirming care cases, some courts have found that these bans on gender affirming care are discriminatory under the Equal Protection Clause and discriminate against transgender people on the basis of their gender. The second is the 14th Amendment's due process clause. And generally, the courts have been somewhat reluctant to find a kind of independent right to seek healthcare under the due process clause. But they have, through about a century of decisions, affirmed the rights of parents to have some control over the upbringing and protection of their children. And they have found that these laws on gender affirming care deprive parents of that liberty without due process of law. So that has been another rationale where courts have been very hesitant to uphold these bans on gender affirming care. And in some instances, courts have ruled in favor of advocates on both claims. They've said these are discriminatory laws, and they also deprive parents of a liberty interest in the rearing of their children. It's likely that these cases will eventually end up before the Supreme Court. Both the 11th Circuit in the case coming out of and 6th Circuit in cases coming out of Tennessee and Kentucky have overturned injunctions, although both courts are kind of yet to rule on the ultimate legality of these bans. So I mentioned that just to say, the abortion litigation on the right to access abortion, the gender affirming care litigation on the right to access gender affirming care, may give some guidance in what kinds of arguments under the Equal Protection Clause and the Due Process Clause might also be available to litigants defending access to PrEP. So with that, I'll pause there and then open it up to questions.
Thank you, Jennifer and Ryan. What a wonderful presentation, informative, and certainly a call for action and advocacy. While we wait for questions in the Q&A section, I would like to go back to something Jennifer mentioned, and just wondering what you think the likelihood of us seeing over-the-counter PrEP and hopefully PEP in the future might be.
Well, it's a two-step process. It starts with the FDA. The FDA has to make a determination that it can be dispensed, safely over the counter. And I think what's optimistic about that, of course, is that they have had an inclination to do that, both with Narcan and now with an over-the-counter birth control pill. So I think that is a sort of a reasonable avenue for discussion and advocacy with the FDA and the medical community, providing the evidence that would be safe. So I think if you're talking about like what would be a in the list of solutions, the first step would be the FDA to look at that issue and make a decision. So I think it really, that's a science question, but I think it's certainly something that would be really worth looking into right now.
Thank you. All right, we have another question here. What are some ways that we as public health professionals and concerned community members can advocate for the health and well-being of ourselves and the communities we serve?
Yeah, I can jump in here. I mean, I think one of the things that we've certainly seen around the gender affirming care context is public health practitioners testifying in front of the legislature, bringing their expertise as medical professionals, and doing away with some of the misinformation that has been very pervasive in these debates. And in the court decisions, it's also been really notable that judges have put a lot of emphasis on credible medical expertise and have spent big portions of the opinion saying, some of these people who testified are not real medical experts on this care. We want to credit those who did come forward on the record and present credible information. That's also true of testifying in some of these court cases when they arise. And I think something similar is likely to happen if there's action at the state level with regard to PrEP, that having people come forward and explain, what it's used for, why it's so important, that does really matter, hopefully in shaping legislators' minds, but certainly in the legal action that follows. And then the other thing that I would say just from the Human Rights Watch research is so many people just don't know where to look for these services, and organizations like Caracol and others are essential in kind of pointing people in the right direction and connecting them to services. But I also think that is something that all of us can kind of play a role in making sure that people know, where services are available, where they're available at an affordable rate, what kinds of transportation people can use to get there, kind of making it as easy as possible for people to access things that may seem just prohibitively difficult to get.
Thank you.
Yeah, and I would it's totally completely agree with Ryan, and the other half of that is just from the total public health point of view. The data of how few providers who might be willing to prescribe or recommend that somebody go to a doctor to talk about PrEP, don't know about it. So I think there's certainly a lot of space for education at every level, both people who actually could prescribe it at the end, but also anybody who might have contact with people who would benefit from it. So, that's something that, no law can stop you from doing, from sharing information. So I think that's a really important strategy.
Thank you. All right, we have another question. What are some resources you could direct us to in regards to keeping up to date as laws change and cases move through courts?
Let me tell you my half, and then Ryan will tell you his half from his view. I think the best possible resource, and I will share the link with Suzanne, and she can share it with you, is an independent foundation, the Kaiser Family Foundation, which is not linked to Kaiser Health, is devoting tremendous resources to tracking these issues. And they really have reporters and lawyers, and their website, I think, is really just an excellent place to monitor this. So that's certainly the first place I look, and I'll share that with Suzanne. It's very accessible, and for a lot of the public health issues, I find them very helpful.
Yeah, I think that's a great suggestion. And most of my work is kind of on the LGBT piece of this. So the other sites that I found really helpful are the ACLU has litigated a lot of these cases around abortion and gender affirming care. And I find their website very helpful because they make a lot of the legal documents publicly accessible. So you can kind of track cases as they go through the system and read the documents and the filings and the amicus briefs kind of as they proceed. And especially on some of these complex issues where they're going up on interlocutory appeal and then back down to a lower court and then up again, it just provides a really clear timeline to follow.
Thank you both. What states seem to be successful in addressing these concerns?
Right, you had all the maps up. I think there's a lot of usual suspects to this, but
yeah, I was going to say there's a new trend now with different states, and certainly kind of obvious ones like California, New York, kind of becoming sanctuary states on issues like gender affirming care and abortion, and pledging that they will not participate in law enforcement investigations of women who have access to abortion, or they will make gender affirming care available for people out of state. Ones that have kind of been proactive in making themselves inviting states for people who need certain forms of medical care. Some states that aren't obvious suspects also fit in that category. Arizona has banned surgical care for transgender children, which is exceedingly rare in the first place. But they're also a kind of sanctuary state for other forms of gender affirming care with the change in the governorship in Arizona. So that's also something that at least on the gender affirming care aspect I could share. But Jennifer, you might know better, like if there's been kind of innovation on the PrEP front in particular states.
So as I'm going to go back to what Ryan just said about, the issue advocacy groups, HRC follows this very closely, Planned Parenthood, all, different groups. But from the other point of view, there's two large sort of national groups, and I will share all these links: the National Association of Attorneys General and the National Association of State Legislatures. Both put a lot of time and resource into this, into trend, what's going on, who's doing what. And those are two excellent sort of one-stop locations to say what's new, what's going on in the state on a whole range of issues. So those are two both very helpful websites I use a lot, because this is fast moving. There's, I would say, as we're sitting here, this is being discussed all over the country. And we'll put together a list, right, Ryan? Yeah.
You. And I just want to mention a comment that Mark put in the chat. He just wanted to add that we are free to reach out to our elected officials with concerns, especially when it comes to any piece of proposed legislation that could impact community health. Sending an email or calling your congressperson or senator with a concise and personable message can be extremely impactful. Thank you, Mark, for that comment. Oh, here's another question. How do you suggest community-based organizations inform and educate medical providers? That's a great question.
So, this is such a this is outside of our law professor lives. But what I saw sort of in, what I see in my public health, when I'm going in my public health meetings and things, is getting people to know more about this so they ask about it when they go to the doctor. So, it's sort of like it's from both ends. So certainly, all the things that everyone is already doing to share information with state medical groups and, give talks and all of that. But I think anything that can be done at the community level, because anybody who would know more about this could be in a position to counsel someone, clergy person, a guidance counselor, whatever. So I think just whatever access anyone has to sharing information, is a pathway to getting it to people who need it and then getting them to a doctor. So that would, but again, I'm sure everyone listening is more of an expert on this, than I am.
Yeah, I'll add that one opportunity we've taken at Caracol is when we get groups of medical students who are interested in coming to the agency and learning from our clients. We are very, very open to that. And I think that's a great way to provide some upfront education about how our clients and the people we work with want to be served. So thank you.
And one other thing that I know, at least in the trans health context, had been somewhat helpful is having medical professionals who do have that kind of expertise and are already doing that work with community organizations to talk about the barriers that they faced or what they've had to think about in their practice as they're integrating some of these concerns. In part because the concerns that community groups bring to medical professionals may not be the same as the hesitations that medical professionals have about expanding services or incorporating new services. And providers who have done that are sometimes able to answer different questions and work kind of symbiotically with community groups.
Thank you, Ryan. Okay. You said a law was passed in 2021 that allows a medical provider to refuse to treat someone based on their religious belief. Can the provider be sued if something happens to the patient who is refused treatment? Another good question.
So my understanding of the Ohio law is that it also insulates providers from liability. If it doesn't only say that they have the right to refuse the service, it also protects them from being sued by the person denied service.
Okay, and then last question. What questions haven't we asked or addressed that you feel would be important for us to know?
I think that, you know, I think it's important to go away from this with the understanding that things are very unsettled, and things that we thought couldn't happen are happening every day. So I think that one of the things that people can do is to follow this more closely, and to be responsive, as the advice was before, to reach out to the people who actually, the front line of stopping this stuff is the legislature, and both local and state. And I think, with everything everyone has to do, you don't want to be constantly monitoring the legal news. But I think in this area, one thing that we've seen is that these are not so much local. Like, these are the laws and the policies are sort of developed by a few people and then sort of fanned out across the country. So if something is happening in one state, I think we have to assume that if it hasn't happened, here yet, that it's in the pipeline. So that's the thing that I would say, is that these things are being, the energy behind these things is not necessarily organic. So that if you've even heard about something somewhere, it very likely could be coming to you.
And then this is not a question that I think we can necessarily answer, but one thing that I think many providers have grappled with and might also be worth thinking about is kind of how to respond when some of these services come under political attack, when medical care of various kinds is being sensationalized, or individual providers who offer it are being targeted. How does the medical institution respond? How does the medical community respond? And to kind of think ahead about planning for that inevitability when some of these things hit local media, or when there are debates over who should pay for PrEP, or who should pay for gender affirming care, abortion, or things like that.
Thank you. We've got 1 minute left, so I'm going to sneak in one more question. Are providers tasked with finding another provider, or is that on the patient in reference to the provider liability question?
So it's dependent on the state and the statute. In Ohio, it says, I believe the statute says that they can make references, but if they believe that the referral itself would violate their religious beliefs, they are not obligated to. And that's another line of cases that we saw coming out of Hobby Lobby, where there were separate cases by providers who said, look, even opting out of providing contraception makes us complicit in the provision of contraception. We don't even want to sign a form saying that we have a religious objection. And the court was pretty sympathetic to that argument. So legislatures can design these exemptions so that there is a required referral mechanism, but in Ohio, they seem to have just said you can opt out of that as well.
And that's such an important point. The thing that really also to remember is that this has been going on with Catholic hospitals for a very long time. So we have a lot of experience with just not even mentioning a treatment that might be relevant. So there's a lot of, this is an opportunity for people, people with the HPV vaccine, reproductive health, all of these issues. This is a good time to work together, because this has been going on a long time in other areas.
Well, thank you, Jennifer and Ryan. This has been a wonderful presentation, very informative, and again, a call for advocacy. So thank you for spending the last hour with us, and to our attendees, thank you for spending the week with us. We really have enjoyed being with you all and holding this space together.